right, we're now live. This is United Gaming LLC as the successor in interest to S&W Amusements Inc. versus Ambika Food Mart Inc. This is 2020 CV 339504. We are on this morning for a hearing on a petition for certiorari, and I think I know the parties, but let's just go ahead and introduce ourselves. I'll go first. I'm Jane Barwick. The person named Scott, would you like to go next?
This is Scott Hoops. I'm on behalf of Mills and Hoops. Good morning. It's good to see you again, Your Honor. And I'm representing the defendants in this action, which are the certiorari defendants and not the lottery or the underlying hearing officer.
Okay, and again, I apologize. It should have gone in order, but my computer shows me, I'm sure, different boxes from what yours show. Mr. Hawkins?
Yes, Jonathan Hawkins on behalf of United Gaming LLC.
Okay, so you're going to start us off, correct?
Yes.
Okay, and would you like to introduce, are these your clients?
These are my clients.
They're not my clients.
All right, Mr. Hoops, you want to introduce your clients?
Sure. This is Dipen Patel and a friend of his that's sitting in to kind of help with the translation. This is Milan Patel. I believe it's his cousin that's helping out today.
All right, and then I should also just note for the record that today is January 27th, 2021. We are all appearing via the Zoom teleconference platform, but again, we are also, as I have said many times now, we are again making our hearing accessible on the YouTube channel. So, Mr. Hawkins, why don't you take it away? And I will just tell you in preparation, I haven't read in every single solitary word of the record itself, but I have gone through your petition, and I'm looking forward to hearing from you.
Thank you. As Your Honor knows, this is not the first time we've been before you on this matter. Well, technically this matter, but not the underlying matter. I think several months ago, we were before you in a previously filed action that Mr. Hoops raised some procedural issues, so we dismissed without prejudice and refiled to remedy those procedural issues, namely just to add the Georgia Lottery Corporation as a party and have them submit the record. And so we believe that's been remedied. And I would start out by noting that I do not believe that the defendants or the respondents have filed answers to this petition in the case. And so I would start off by saying I believe they're in default.
Something on the docket, and I'll let Mr. Hoops speak to it, but I didn't mean to interrupt you, but there's something on the docket called answer, and when I clicked on it, it just looked like an index.
So the answer...
I believe...
Go ahead, Mr. Hawkins, whoever.
I believe that was the Lottery Commission or corporation answering and submitting the record is what I believe that is, but okay. I'll let Scott talk.
That makes sense. Go ahead.
Yeah, so the Certiorari Statute is a creature created by the legislature. It's a specific and exempted procedure that does not follow or coincide with the Civil Practices Act. It only requires that a petition be filed. It puts the burden on the petitioner to also file a bond, certificate of cost. It's under OCGA 541 et sec, and the only answer that's required as part of a certiorari petition is by the underlying hearing officer that's filing the answer. There's no requirement whatsoever in that statutory scheme for us to come in and also file an answer or contest. In fact, that's not appropriate. What the petition.
Well, I didn't mean to hijack Mr. Hawkins' argument. I clearly just misunderstood that entry. So let's keep going, and then I'll let you address that argument, Mr. Hoops,
Thank you,
when
Your Honor.
we get to you. Go ahead, Mr. Hawkins.
Very briefly, to continue on that, while this is styled a cert petition under the underlying statutory scheme for the COAM arbitration regime and administrative process, it states that an appeal from the decision of the lottery CEO is made to the Fulton County Superior Court. So again, calling it cert, we are aware of other vehicles that parties have taken to appeal from the lottery CEO decision, and we think calling it cert versus an appeal is really form over function, and we would assert that, still assert that it is in default because no answers have been filed, no responses, and because of that, we would just state that it would be appropriate for the court to grant the remedies that we have asserted in our petition. That would be, well, it's in the last paragraph of our petition. I won't repeat it here, but I would start by saying that I think it's appropriate to enter default and just rule on what we've asked for in our petition. Moving on to the merits, because I understand Mr. Hoop's going to object to that assertion. I'll try to, first I'll ask the court, I went through this in very great detail last time, and I don't know if you recall that or if you have any notes. I'm happy to go in as much detail as you would like, or I can go more high level if the court would prefer.
Well, I'm going to sort of let you make your argument. Of course, I do have notes, but I'm always anxious to get brought up to speed. So maybe a little somewhere in between. How about that?
Okay. All right. I'll start, and you tell me if I'm going too deep.
Okay.
So we're here, as you know, on an appeal from an arbitration proceeding involving the COAM video lottery machines. And a decision was made by the arbitrator. It was appealed to the lottery CEO. No decision was, or no opinion was issued by the lottery CEO within 30 days. It was deemed denied as a matter of law. And this is an appeal from that decision of the CEO, basically affirming the arbitrator's decision. As I mentioned earlier, I represent United, which is a successor in interest to S&W. So I'll probably talk about S&W, but United's one and the same for this purpose. So S&W was a master location licensee, and it had contracts in 5 locations. They were all operating as quick stop gas stations. The owner of 4 of those locations was BK Patel Investments, LLC. One of those locations is being dealt with in a different proceeding, so we're only going to be dealing with 3 of those here, and that's number 92, number 100, number 204. And Milan Patel was an owner and or officer of BK Patel Investments. The other location is Ambika Food Mart, and Milan Patel was not an owner or officer of Ambika. Now, at some point, BK Patel and Ambika transferred ownership of all 5 locations to different companies, and it's listed in the caption. I won't go through that. All of these locations were subject to COAM location contracts. And per those contracts, if proper termination notice is not provided, the contract terms automatically renew. And so the issue before us here is whether or not proper termination notices were provided for the 4 locations before this court. The arbitrator held that the locations substantially complied with the contractual termination provisions and that the contracts were properly terminated. S&W appealed to the GLC lottery or the GLC CEO, stating that the arbitrator erred in that decision. And as I mentioned earlier, no decision was issued within 30 days. And as a matter of law, they were deemed denied. Our argument here today is that this court should reverse that denial. The standard review is that the decision of the GLC CEO should be overturned if the findings of fact are against the weight of the evidence, and the legal conclusions, or I should say, legal conclusions constitute an error of law. And here we have both. So let me start with the termination. We contend that the contracts were not properly terminated. There are unambiguous contract provisions that are the same in all four contracts. So I'll speak about them as if it's one, but it's the same provision in all four contracts. In paragraph 12, the termination provision, it states that the notice must be served at least 3 months, but not before 4 months prior to the termination of the term or the expiration of the term or any renewal thereof. And then there's a separate notice provision, paragraph 18, that states any notices that are to be sent under the contract, including the termination notice, must be given via certified or registered mail, return receipt requested. Now, the purported notice in this case was May 30th, 2017, in an email sent by Milan Patel. The email does not comply with the termination or notice provisions, either strictly or substantially, in our opinion. An issue that we anticipate will be raised by Mr. Hoops is the question of time is of the essence. It appears that in the arbitrator's decision, he found that that concept did not apply here. And we argue that it should, and that it should be implied into the contract. In Forsyth City v. Waterscape Services, 303 Georgia App 623, court states that it's a cardinal rule of contract construction that a court should, if possible, construe a contract so as not to render any of its provisions meaningless and in a manner that gives effect to all contractual terms. And using that construction rule, it's clear that the email notice was not proper. But it's more than just the timing. So it was not in the proper window, and it was not sent via certified mail. Moreover, the notice that was sent only states, quote, contract, close quote, in the singular. As I mentioned, there were 5 locations with 5 different contracts and different termination dates. And so it's not clear what contract was being terminated. It did not state contracts in the plural. It did not state the contract locations specifically. So it's really not clear as to what that would apply to. And I would argue that it should be construed against the party that sent it. Now, that email notice cannot apply to the Ambika contract because Milan Patel was not an owner or officer of Ambika Food Mart. So at a minimum, with respect to Ambika, it would not even apply. It appears that the arbitrator did not take this evidence or the law into account, and we believe that's error. And we believe the affirmation or the decision by the CEO not to reverse that is error. Now, as to, there was a second notice that was sent for location number 92, and that was sent on July 18th, 2018, and that was sent by an attorney. And we contend that the fact that that second notice was sent supports our view that the email notice was insufficient. And as to the July 18, 2018 notice, we still contend that was not sufficient. It was sent on behalf of BK Patel Investment, but according to BK Patel, sometime between December 23rd, 2017 and April 5, 2018, BK Patel transferred its ownership and or control of number 92 to another company, and that was 1450 West Bay Street, LLC. So when it was sent on July 18, 2018, that notice was not sent on behalf of the actual location owner at that time. And we contend that makes it improper, or that it does not comply with the notice provision under this contract. Now moving on to
Hawkins, not sent to the actual owner or not sent on behalf of the actual owner?
On behalf of.
I thought I wrote that down correctly. Okay.
Thank you. And now I want to move on to another topic, and that is whether or not the new owners assumed the contracts at issue. And we contend that they did, either impliedly or expressly. Now, this dispute was referred by the lottery to arbitration on April 23, 2018. And the new location owners had been receiving their cut of the COAM revenues prior to those arbitration referrals. And I can go through the specific dates, but sometime between December 18 and 2017 and April 5, 2018, the various locations were transferred. The ownership was transferred to the new owners, and they continued to receive revenues after that. And under law, you're required to have a written contract in place in order to receive revenues. And under OCGA section 50-27-87 sub B, sub 3, sub C, a new location owner is not allowed to receive revenue or operate COAM machines in their locations unless they formally accept written agreement from the prior owner. And they did, in fact, receive such revenues. And so either there was a formal assumption of the contract, which we did not receive a copy of, or they did so via implication. And there's no evidence in this case that the new location owners, and I'm not talking about Ambika or BK Patel, but the new owners, there's no evidence that they provided termination notices under the contracts that they assumed. And so it's our view that those contract terms were extended per the terms of the contract. The arbitration award did not address those issues at all. The CEO did not address those issues at all. And we believe that is error and should be reversed. And let me go through specifically what we contend should apply to each location. So I'll start with number 71. That term was set to end June 29, 2018. Contract says it's a 30-day extension, but by contract or by the law, the minimum time for one of these contracts is 1 year. And so our contention is the assumed contract ended June 29, 2020, and no notice was sent, so it automatically gets extended to June 20th, 2021. On location number 92.
Wait, just 1 second.
Okay.
Okay. Location 102.
Okay. Number 92.
92, I'm sorry. Okay.
The term was set to end November 17, 2018. And that location was purportedly the location that the second notice in July 18, 2018 was sent for that. And that was not within the proper window. And so that would mean that the term would extend automatically 2 years, which would put it at November 17, 2020. But again, there was no follow-up notice or termination notice sent in 2020. So our contention is that that contract would extend to November 17, 2022. Moving on to location 100. That term was set to end December 1, 2019, and it had a 2-year term that automatically renewed if termination was not properly provided. And so that would have extended it to December 1, 2021. And the last location at issue here is number 204. That term was set to end June 30th, 2020. It had a 2-year term that automatically renewed if termination notice was not properly sent. And so because it was not sent, the term gets extended to June 30th, 2022. And so moving on to the next topic, which and I'm reverting back to the old owners, which are BK Patel Investments and Ambika on this issue. And that is, even if this court finds that the arbitrator and the CEO, GLC CEO, did not err in their holding about the termination notice, the arbitrator and the CEO erred by failing to find a breach of contract by BK Patel and Ambika. And more specifically, we contend they breached the contracts in 2 ways. The locations were required to maintain all necessary location licenses during the term of the contract. That was the contract term. Now, under the COAM statutory scheme, it is unlawful for an owner of a location license to also own any piece of a master license. There are 2 tiers and they have to be separated. You can't be in both tiers simultaneously. Now, during the terms of the contracts, the owner of the locations, Milan Patel, bid for and ultimately received a master license, which meant that the old locations could not and did not ultimately maintain their location licenses. And that conduct by Mr. Patel, the owner of BK Patel, meant BK Patel breached the contracts. Now, the other contractual provision that we contend was likely breached was paragraph 11 of the contract, which is a duty to obtain a written assumption by any entities that the locations were sold to. We never received, that I'm aware of, any written assumption of the underlying contracts. So to the extent that that did not occur, then that was a breach of those location contracts as well. And the arbitrator and the GLC CEO did not so hold, and we believe that was error, and we believe this court should reverse that. Lastly, just point out that the contracts provide for prevailing party attorney's fees. Paragraph 13, we assert that there were clear breaches of the contracts that required S&W to protect its interests in the arbitration. S&W and United now have incurred litigation costs and fees, but the arbitrator and the GLC did not award those fees. And we would ask that this court reverse that ruling and remand for a hearing on the issue of attorney's fees. And with that, if the court has any questions, I'll be happy to answer them.
I do, Mr. Hawkins. Just remind me, if this court, and this, don't anybody get excited because this is just a question. If this court were to reverse, is that the appropriate remedy, remand? I don't substitute my own judgment.
So what we are asking for in the petition is an order from this court ordering the GLC CEO to vacate the arbitrator's award. We would ask that this court remand it to the CEO with instructions that the arbitrator should reverse and declare that the email notice was not in substantial compliance and therefore not valid. We would ask that your order of remand send it back for adjudication at the lower level, whether via the CEO or the hearing officer. And that this court just stay the final award.
Now, in the sentence that you just said, does hearing officer equate to arbitrator?
So I think this court has some discretion, and well, let me back up. I think the GLC CEO has some discretion. The CEO could decide it on the merits, or the CEO could decide to refer it to the hearing officer. I think practically the CEO is not going to hear it. So I believe the order from this court would be, I would say, either the CEO reverse it or refer it to the hearing officer to reverse it. Or let me back up. You reverse it, they refer it to comply with your order, which would be hold that the email was not in substantial compliance.
Okay, I guess let me ask it a different way. Was the arbitrator appointed in this case as the hearing officer? I guess I'm a little lax on my
okay.
administrative terminology.
Yeah, sorry, I apologize for that. So the way it works currently in the administrative proceeding, the CEO is allowed under law to refer any disputes to a hearing officer to be decided. And the general practice is they get referred to an arbitrator. Now, there's not a specific arbitrator that they're referred to, but the hearing officer is typically not the CEO.
Okay.
So then there's an arbitration proceeding. And then from there, a party can appeal to the CEO to review that hearing officer's decision.
Okay.
And then from there, it gets appealed to this court.
Okay. Now let me ask a question of equal horror to you. Where does my decision go? Is it automatically? Can you appeal automatically, or do you have to get a certificate? I mean, do you have to appeal by application?
No. If your decision can be directly appealed to the Court of Appeals.
Okay, that was my question. Okay, and the standard there is would the standard there be to send it back to me, or to send it all the way back?
Based on my experience, it would come back to you.
Okay.
With direction, likely.
Okay. All right.
So I think
no one other than the CEO or the hearing officer redoes any evidence, in other words.
I suppose you could order them to hold further proceedings in line with anything that you order, but I'm not sure there's a prohibition on them hearing more evidence.
Okay.
Scott may have an opinion on that, but I've not seen it one way or the other.
Okay, and let me ask one other question, and then I'll ask Mr. Hoops the same set of questions. But can I look down into the record before the arbitrator? Same evidence. Here's the email. Here's the certified letter. Can I look at that same evidence and come up with a different conclusion?
I think you can.
Okay. Okay,
I
thanks.
think, so to sum it up, I think you could reverse and substitute your determination, or you can remand with instructions for them to do it.
Okay. Okay, great. Thank you. Okay, we'll Mr. Hoops?
Good morning again. So just for point of reference for the court in responding to your inquiry concerning what the court is allowed to do as part of your review, that's found in OCGA 5-4-14 is where the answer is.
Okay.
And that allows the court, upon hearing the writ, to order the same to be dismissed, which I think is the right thing to do in this case. Or it says you may return the same to the court from which it came with instructions. And so that to me would be the underlying tribunal, which would be the hearing officer that heard the underlying matter, and not the CEO of the lottery that didn't even review it, didn't even enter any order, failed to act within the 30 days, which in my experience for several years now, the CEO of the lottery has never responded to a motion for review or gotten involved in any of these cases whatsoever. And so I think that's where the direction would be. OCGA 5-4-14B says in all cases where the error complained of is an error of law, which must finally govern the case, and the court is satisfied that there's no questions of fact involved which make it necessary to send the case back for a new hearing before the tribunal below, it shall be the duty of the judge of the superior court to make a final decision in the case without sending it back to the tribunal below. And so if there's certain issues of law and you don't believe that there's essential issues of fact that would require further hearing, then I believe that you're vested with the authority to enter a final decision in the case.
Okay.
And so we had arguments in this case before. In fact, a pre-hearing brief was submitted. We had a very lengthy hearing before Your Honor. And we also had post-hearing briefs that the parties submitted to the court on deciding this issue. I felt pretty good about my argument, especially after I received a dismissal without prejudice. And I chalked that up as a win in my column. However, the issue is, do they have the right to refile their certiorari case? Because the laws governing certiorari, again, are a creature by statute. And the courts have decided in the past that issue of whether a writ of certiorari petition can be dismissed beyond the 30-day mandatory filing and be refiled. And the answer is yes, except there's certain exceptions which I will direct the court to in my argument, and that I contend that does not allow them to refile. To quickly, so I don't forget to address the default issue, OCGA 549, for example, it says the petitioner or the defendant, which the defendant is the opposite party, I believe is how the courts have referred to them. The only filing requirement that is put on a defendant is that the defendant in certiorari may traverse or accept to the answer of the respondent, which would be the underlying tribunal. That's important because at no point is there any reference to any mandatory filings. And I would say this because what they're asking the court to review is not issues between the parties themselves. A certiorari petition is filed for the court to review the underlying hearing officer's ruling. That's why you have to serve. You actually have to effectuate service on the underlying hearing officer. Under OCGA 547, it actually says that the petitioner, all they have to do is send a copy of the answer to the opposite party, to the defendant, by mail or just delivered to them personally. That's certainly not the standard that we have under the Civil Practices Act of getting somebody served and then they have X amount of days to file an answer. This one says because the petition is filed against the underlying hearing officer, so you file it against, in this case, the lottery, and then you just mail a copy to the defendant. Why? Because they're a participant, of course, in the case, but you don't have to even serve them, nor do they have to file an answer, except that they're allowed to traverse the answer if they contend that the lottery did not file a complete and accurate copy of the underlying matter. And so on that ground, there cannot be a default, nor, and I've searched this, nor have I found any cases where the opposite party that is not the underlying tribunal was ever hit with a default in a certiorari petition. Why? Because that's just not part of what a certiorari petition is. There cannot be a default. Now, the other matter that I think we even talked about before was, and there's recent cases addressing it, is if the lower tribunal fails to file an answer within 30 days and the effects that may have on a petition. But that's certainly not anything to do with whether a opposite party is required to file an answer. So the reason why I brought up what happened with the dismissal of the previous case is because there's no question that in the original cert petition that was filed, that there was never a certificate of cost that was signed by the lower tribunal, by the officer, the hearing officer that actually heard the case. In fact, it was signed by a Stephanie Fairburn, who was identified as the controller for Miles Mediation. And that's what a bulk of the hearing was dedicated to at this last go around when we were originally before the court. It appears that this defect was corrected the second time around. And it's kind of a strange, like a 3 or 4 page certificate of cost that talks all about how he had no idea when this was originally filed. He wouldn't even be the guy that would know about the cost. So he's relying on the same controller, which is what they dismissed it for originally, and just says he's relying on her. He's not aware of any certificate of cost. But I will acknowledge that this time around, a certificate of cost was filed by the underlying hearing officer, which is what the statute requires. And in fact, OCGA 545A is the statute, and it says, before any writ of certiorari shall issue, except as provided in subsection C of this code section, the party applying for the same, his agent or his attorney, shall give bond and good security, conditioned to pay the adverse party in the case the sum sought as an award to be recovered, together with all future cost, and shall also produce a certificate from the officer whose decision or judgment is the subject matter of complaint, that all costs may be accrued on the trial below have been paid. And so that's a required step, is to have that. Okay, they have it this time, but what happens if they didn't have it the original time and this is part of a refiling? In Veal versus Eagle Fire Insurance Company, 103 Georgia App 757, Court of Appeals held that it is necessary that in all applications for certiorari in civil cases, bond be given in an amount approved by the trial judge, and that such judge certify under his own signature that the bond has been approved and that the costs have been paid. Otherwise, the certiorari is void. That's the language that this court says. It's not voidable, it's void. In a more recent case, Targovnik, Targovnik versus City of Dunwoody Zoning Board of Appeals, 307 Georgia App 140. That case, the Court of Appeals cited the Veal case and stated, historically, Georgia courts have required that the certificate be signed by the judge whose decision the applicants seek to challenge, or the certificate is void. Echoing that the Veal case. And so they went through an analysis in that particular case, and they were talking about, and I think it's more relevant to the first, but for purposes of this argument, a recent case in 2010, they reiterated the position that if you don't have that certificate of cost, that the certiorari is void.
So is your argument, Mr. Hoops, that the first dismissal that does it?
So the first dismissal does it unless unless there were amendable defects where a party could amend throughout the certiorari petition. So for example, OCGA 5410 provides that cert proceedings shall be amendable at any stage as to matters of form or substance as to the petition, bond, answer, and traverse. And a valid bond may be amended or substituted for a void bond or no bond at all. And so that tells you that there are 4 specific matters that if you don't, if you made a defect, if there's an error in it, you can go ahead and you can amend that, which would mean that any dismissal that was based on a defect that was as to the petition, bond, answer, and traverse, that makes it voidable, not void. And so the courts have specifically said that there are 4 things that you can change or you can amend but it's confined to those 4 cases. In Cobb County versus Heron, 230 Georgia App 482, they reaffirmed the limitations set forth in OCGA 545 as follows. They said, and this is talking about the sanction. It said, the applicant insists, however, that the absence of a sanction was amendable in accordance with OCGA 5410. And they said, we disagree. In interpreting statute, courts must look for the intent of the legislature and construe statutes to affect that intent. All words except words of art shall be given their ordinary significance. As the dissent aptly points out, the Act of 1961 was passed to clarify and simplify the procedure in cert proceedings, as well as to repeal the prior statute as a substitute for the new section providing for amendments. In this new OCGA 5410, the legislator listed the documents that could be amended as to form or substance at any time: the bond, petition, answer, and traverse. Had the legislator intended to allow for an amendment of a late sanction, it would have included it in that particular code section. Well, the certificate of cost is one of those that was not specifically identified in 5410. And in this case, the Court of Appeals said the words in statutes matter. And if the legislature wanted to also say, because they're referencing the bond even, if they wanted to say that the certificate of cost could be amended, they would have certainly said that as they went through the procedure. So in a case, Buckler versus DeKalb County, 290 Georgia App 190, the Court of Appeals specifically said the privilege of dismissal and renewal under OCGA section 9261, which is giving them the right to come back before this court, it says does not apply to a case dismissed on the merits or to a case which was void when dismissed. And so we have several cases that specifically say that it is void as a matter of law if the certificate of cost are not paid. So when they originally filed it, it's nice. I'm glad that they recognize this. And I will say it was not Mr. Hawkins, once again, that filed the original petition. I hold him in high regard. He came in later in the case. I got a thumbs up from him. But I think he was left to take this matter over when his client acquired the predecessor licensee. And I think he did the right thing. I think he recognized that there was a procedural defect that happened. I think he was right to dismiss without prejudice and to try to refile. But the problem is you can't refile if the original cert petition was void as a matter of law. And the cases are clear, it's void. Not voidable, it's void.
Let me ask you, Mr. Hoops, what in the original petition for cert that was dismissed and the bill was sent by Miles, was that, were the costs paid, just not the correct certificate?
No, so the issue was,
and I'm sorry, because I know I'm asking you to relitigate something that in the past.
No, not at all. I'm asking you to hear about things relitigated in the past, so fair game. No, so again, the statute, the cert statute requires strict performance, and you have to follow this. A lot of it's silly, and I think there's a recent Court of Appeals case where one of the justices said, the legislator needs to come in and fix this. It's draconian, it's nonsensical. There's all these steps that somebody has to take, and somebody should just be able to pick up a statute and know what they're required to do. And there's all the case law going back over 100 years that says if you don't strictly comply with the writ statute, then it's dismissed. And the judge is telling the legislator, you got to fix this. But nonetheless, this is the law, and although harsh, it's not for us to decide. We're just here to interpret the law. And so when the original certificate of cost was signed, it was signed by an accountant or a controller at Miles Mediation that said she's looked and all the costs have been paid. There's no costs that are due, nothing. The problem with that is that it is a requirement, and it is very specific, that says the only person that can do it is the actual underlying hearing officer. In fact, there was one case that deviated from that, and that was the Targovnik case that I cited earlier. And that one was, the question was, how does a party appealing from a multi-member board obtain a certificate from the officer whose decision or judgment is the subject matter of the complaint? How do you do it if you've got a whole board of people? And in this, the appellate court resolved the issue by recognizing a limited exception. The Court of Appeals overturned the Superior Court's dismissal of a writ of certiorari on the grounds that the certificate of costs were signed by the secretary for the City of Dunwoody Zoning Board of Appeals, as the City of Dunwoody contained a specific ordinance and charter that specifically authorized the appointed secretary for the City of Dunwoody Zoning Board of Appeals or his proxy to issue the required certificate of cost in a certiorari case. They said that was the one exception that you can do this. And it better be in an ordinance, in a charter, and on the record books as a matter of law. Well, I'm quite confident that there's nothing that's of record or as part of the law that would allow a controller or an accountant at Miles Mediation to substitute herself for the underlying hearing officer to circumvent Georgia law pertaining to a certificate of cost that's required to file a certificate for certiorari review.
So it had to have been signed by McKinney?
Yes, the underlying hearing officer.
And not, could the lottery corporation have signed it?
No. The Certiorari Statute specifically says the only person that's allowed to sign it is the underlying hearing officer.
Okay.
And in fact, the bond issue is interesting. The bond, I mean, they go into a separate part that the bond can actually be signed by a party, his attorney, an agent, or somebody that basically offers to provide some form of security that the cost will be paid. But it specifically says that the certificate of cost must be signed by the underlying hearing officer.
And that is the applicant, the certiorari applicant's duty.
Yes. It says before any writ of certiorari shall issue, the party applying for same, his agent or his attorney shall give bond and good security. And then it says, and shall also produce a certificate from the officer whose decision or judgment is a subject matter of complaint, that all costs which may have accrued on the trial below have been paid. OCGA 545A. So there's actually a relaxed standard for a bond, but then under the certificate of cost, it's that they're very specific who is mandated to sign that certificate of cost.
Well, you listed earlier the bond as possibly amendable.
Correct. Because it's under OCGA 5410, it's one of the four matters that say that you can amend this as a matter of right at any time throughout the certiorari stage. A certificate of cost is not one of those. And the courts have been very clear. In fact, the courts in the case that I cited said, here are the four things that you're allowed to do that the legislature has said. Those four things. And if it's not in there, too bad. You're not allowed to amend this. It means it's void as a matter of law if you don't do exactly what you're supposed to do and you don't fall under those four exceptions.
If this court, and again, here's one of those horrifying questions, but it is purely arguendo. If this court were to decide on that basis, would that go to the Court of Appeals?
Well, that would certainly be something I think that would have to be discretionary. I think the law is pretty well established on that fact. I think they can apply for appellate review. And again, I'd have to research that, and I think counsel would as well. But I think that if it's dismissed,
Who in the world would want to review that? Because they're just going to come right back and say the legislature should do it.
exactly. And I think the case law has been very established. It's clear that says if you don't do it, then you've lost your right to seek this certiorari review. So they refiled it, but they refiled it based on a void petition of writ of certiorari. You can't do that.
Okay.
Cases are clear.
Okay.
And so turning to the actual merits of the case. So number one, in City of Atlanta Government versus Smith, 228 Georgia App 864, the appropriate standard of review recognized by the Court of Appeals to be applied to issues of fact on writ of certiorari to the Superior Court is whether decision below was supported by any evidence. And you look at this strange exception that the Court of the Georgia Lottery has mandated. So the Georgia Lottery has required that all disputes between licensees have to go through arbitration pursuant to OCGA section 50.27.102D. And that specifically says that the rules in the arbitration are to be consistent with Georgia's arbitration code. And the cite to that is OCGA section 50.27.102D3. And so when the parties go to arbitration, they're required to proceed to arbitration under the Georgia's arbitration code. And that's important also because then you look at cases involving how arbitrators review the law and the facts to the law. The Georgia Court of Appeals addressed the standard in Georgia for contract compliance. And this is important because I would note that the arbitrator specifically went through an analysis and cited the case law that's been relied upon by both the petitioner as well as the defendants or the opposite party. And this is what's being appealed for the court to review. And he's talking about, he sets forth these findings of undisputed material fact. Well, when he's making these findings, the court basically, it's an any evidence standard at this point. If there's any evidence, this court cannot go in and change or undo or reconsider issues concerning fact. And he goes through 1.5 pages, 9 specific paragraphs in his order where he's talking about specific findings that he has found that are undisputed based on the argument and evidence before him. For example, he cites that the location contracts at issue in this case, they contain detailed termination provisions, but they do not include time is of the essence clauses or any similar language. He goes through and talks about the notice that was sent, the history between the parties, the established history, the familiarity of the parties, the reasons why the email notices were sent concerning the termination. And then he goes in and he sets forth conclusions of law. In the conclusions of law, he goes into the 2 main cases that both sides have referenced in their briefs. He goes into Del Lago Ventures, Inc. versus Quick Trip Corp., 330 Georgia App 138. And he also talks about Salon Automated Services, Inc. versus Corporation of Mercer University, 221 Georgia App 856. So he looks at how these 2 cases, he looks at these decisions He applies the facts, the undisputed facts, to these decisions, and he comes up with his order based on his review. And so if you look at the Del Lago case, the Court of Appeals held that the general rule in determining contract compliance is substantial compliance, not strict compliance. And this rule applies to a contract's termination clause as well. And then the court cites Rome Healthcare versus Peach Healthcare System 264, Georgia App 265. In Del Lago, the court further emphasized that substantial compliance, not strict compliance, is the general rule. As to strict compliance with the contract's termination clause, now here's the exception that the Court of Appeals said. The court held that strict compliance is the exception, which only apply to cases concerning termination notices that result in forfeiture of real property rights under a lease or easement or revocation of a surety. The court concluded that none of the circumstances are present here, as termination of the contract would not have resulted in the forfeiture of real property rights under a lease or easement. These are real property rights. I think I had an analogy, COAM machines, these coin-operated amusement machines that I know the court probably has heard a lot of in many courts down there. The dockets are starting to be filled with these COAM lottery machine cases. It's the same thing as a Coca-Cola beverage, machine. Well, you have to go get a supply contract to get that, and you put it in there, but that doesn't confer any real property rights on Coca-Cola. They can't come in there and occupy that. They just lease their machine, and then when it's up, it's up. It's the same thing. The petitioner did not obtain any real property rights. He placed his machines in there, and then when the contract is up, you have to take your machines out. That's not real property rights. That's leasing equipment or machines to a location. And so the arbitrator did this analysis of strict compliance versus substantial compliance, cited the Del Lago case, and specifically found that strict compliance was not required based on the Del Lago case because it didn't confer any real property rights. So if strict compliance is not the rule and it didn't confer real property rights, then substantial compliance, and the court went through a history of what happened, when, why, who, and found that there was substantial compliance. As you're going under and proceeding under the arbitration code, you look at arbitration cases, and the petitioner cannot show that the arbitrator manifestly disregarded the law, specifically because he analyzed the two cases and looked at it and applied it to the facts. And in fact, that's a very high standard for somebody to say that a hearing officer or an arbitrator manifestly disregarded the law. In Johnson Real Estate versus Aqua Industrials 282 Georgia App 638, the Court of Appeals addressed the concept of as to whether an arbitrator manifestly disregarded the law. In that case, they held that, but manifest disregard of the law, a concept originating in federal common law, has never been the equivalent of insufficiency of the evidence or misapplication of the law to the facts. It is a much narrower standard. As interpreted by the federal courts, manifest disregard of the law requires that the governing law alleged to have been disregarded is well-defined, explicit, and clearly applicable. And two, proof that the arbitrator was aware of the law but decided to ignore it. Thus,
that's my standard on review of legal conclusions or the conclusions of law.
Under the conclusions of law, you're looking at an arbitrator, and you've got to show that there was a manifest disregard of the law. Under those two standards, it says that you have to show that the applicable law was deliberately ignored. So in that case, where he says, look, I understand the law, I get it, I don't care what the law says, which I had an arbitration case one time where the arbitrator on a construction case said, I know what unjust enrichment is, I know what it doesn't apply here, but I'm going to put it in there. Like, well, thank you. You just manifestly disregard the law. It's such a hard standard. You have to show that he's aware of it, and even on record, he has to make some type of a statement that he is choosing to disregard the law, even though he knows that that's not the right thing. And so I don't think there's anything in this. I think it was a very thoughtful, thorough analysis backed up by facts. Sometimes you see these cases where you have an arbitrator issue a 3-page order, and there's no way you can figure out how he arrived to that. This one was a thoughtful analysis under separate headings that said, here's undisputed material facts. Now, none of those undisputed material facts are being challenged. At no point are they saying that those were wrong, that those were false. They're just saying, look, it's undisputed. These facts may be undisputed, but he applied the wrong law to it, and we feel like it should be strict compliance, except for the fact that the Georgia Court of Appeals have routinely said that it's substantial compliance unless there's real property rights being conferred. And so we would contend, Your Honor, that the arbitrator thoughtfully and thoroughly analyzed this, reviewed the facts, made specific findings, correctly applied the law. And so to the extent that the court allows the case, number one, even to proceed to a judgment based on the fact that it's void, the refiling, you can't refile a void petition. To the extent the court feels that or rules in their favor that they can, then we just contend that the arbitrator correctly applied the law to the facts. It's based on an any evidence standard, and there's certainly any evidence that these facts took place, mainly because they're not being disputed. It's just that they don't like the reasoning and the legal conclusions that were reached, which, based on the law, were the correct legal conclusions.
Let me ask you a question, Mr. Hoops, because a large problem, and I'm absolutely serious about this, a large problem with Superior Court judges is that we so frequently have on our equity hats, we get sort of, it infiltrates through our, fairness infiltrates through our brains when we're looking at everything. And I think the answer that you would give me is, look, we start with the fact that the lottery in and of itself is a statutory creature.
Correct.
And statutes must be strictly construed. So we have the first layer is that this is a statutory creature, and it's not the court's business to decide what's fair. Then we layer on to that sort of the administrative, I'm using this colloquially, not technically. We have the sort of the administrative practice underlying that construction. Then on top of that, we have the layer of the rules of certiorari in which we're telling superior courts, here are your guardrails, stay in the lines. Because at the bottom of this, you're going to have somebody say, was an email enough?
Mm-hmm.
So just get me over that bump. Was an email enough?
Well, I would say this. I think that the court looked at the contract. They looked at what happened between the parties. And I would go back to the case, is it enough under the contract, right? Was the email enough under the contract? In that Johnson real estate case that I cited previously, the Court of Appeals specifically said it is not the function of this court to second guess the arbitrator's interpretation of the contract, period. Is it enough? The arbitrator found that it was enough, and the arbitrator found that it was in substantial compliance with the terms of the contract.
And I think that what tickles rather the question, or what teases the question out, is the concept of industry practice, because going going over to construction law or any other industries where there is decades and almost centuries of law arising out of practice, rules of practice. But when you hear that, you are always mindful that the parties could choose to include that or not. And this contract apparently said, here's how you terminate. But I think the answer is still going to be the arbitrator knew all that.
Yeah, I think there's a very important case for the court to consider, and that's DeKalb County versus Bull, 295 Georgia App 551 2009. And the Court of Appeals more fully detailed the requisite standard of review in certiorari by holding that the appropriate standard for review to be applied to issues of fact is whether it's supported by any evidence. And then the court goes on further and says, neither the Superior Court nor this court reweighs credibility determinations of the fact finder. In other words, because the fact finder in the initial proceedings is charged with weighing the evidence and judging the credibility of the witnesses, the Superior Court and this court must view the evidence in the light most favorable to the fact finder's decision and must affirm the decision if there's any evidence to support it. Even when the party challenging the fact finder conclusion presented evidence during the initial proceedings that conflicted with those conclusions, it is also important to note that the present appeal is one of certiorari, and neither party has sought to vacate or confirm the arbitration award. So
Well,
the court,
you just seem to have an answer to everything, and I think your answer is to keep my big fat equity nose out of the arbitrator's business.
that's the Court of Appeals answer. That's not mine.
Okay. Anything else?
Not on my side. No, Your Honor.
Okay, Mr. Hawkins, I'll let you have the last word, sir.
Yes, I want to address a few things here. First thing, I think the any evidence standard is not what applies in this proceeding here before this court. When the CEO and I'm sure, let me back up. I'm sure Scott would agree with me on this. There's a huge volume of cases that come before the CEO on administrative appeals from these arbitrations. I don't know how the CEO, in addition to her normal duties, would have time to look at any of these cases. And I'm not aware personally or otherwise of any case where the CEO of the lottery has actually issued an opinion on an appeal to her. They are not ruled on ever, and via the statute, they are deemed denied after 30 days if no opinion is issued. And back to your point earlier about the lottery and this procedure, it is a creature of statutes. The statutes may not be super clear in terms of how they work, but they state what they say in an unambiguous way. And by the CEO not making a decision within 30 days, by statute, they are making a decision, and it is deemed denied. And before this court, the standard is, under the statute, was the decision of the CEO. It's the two standards. The findings of fact of the CEO are, quote, against the weight of the evidence, or the legal conclusions constitute, quote, an error of law. Once the CEO decides not to issue an opinion, the CEO de facto is adopting all of the findings and the legal conclusions of the arbitrator, and therefore the standard of review before this court under the statute is what I just said. Scott mentioned the manifest disregard standard. That's in the context of moving to confirm or vacate an arbitration award. We are not arguing that standard applies here either. We are not moving to confirm or vacate an award here. Again, you got to look at the statute. The statute says the two standards, which we've talked about. Another point I just want to make, Mr. Hoops stated that there are no property rights involved here. We would disagree. Under paragraph 2 of the location contracts, it states, quote, proprietor shall provide space at the location for the installation and operation of the machines for the duration of this agreement and for any renewal periods. Proprietor shall ensure that the space is a conspicuous place and is readily accessible to the public patronizing proprietor's premises. Proprietor shall not reduce the space allocated for the installation and operation of the machines. I think in 3 different sentences there, it talks about space, which is real estate. Now, this is not a traditional lease. We would say this is more of a license to use designated real estate within the premises. So I think this does involve real estate and rights, real property rights in the location. Couple of other things quickly I want to address on the procedural issues raised by Mr. Hoops related to the certification costs. And this is sort of on the fly with not going super deep on research, but there's some case law that we think provides some nuance on the strict compliance approach that Mr. Tripp says applies on a certain deal that we think will allow substantial compliance. The first part would be we think if costs are actually paid, then a party can amend the certification reflecting the costs that were actually paid. And I think an opinion that would support that position is Quinn v. O'Neill, 57 Georgia App 248. The other thing I would say is that we think substantial compliance would apply for the certifications of costs. I'm going to give you a couple of sites there that would support that position. One is Delinsky v. Dunn, 206 Georgia 825, and another Beard v. City of Atlanta, 91 Georgia App 584.
All right.
And that's all I have, Your Honor.
Okay. Well, listen, this has been wonderful. I appreciate everyone's doing such a great job. We will get something out just as soon as we can. In all likelihood, we will ask one or the other of you to actually reduce it to writing, but we'll get a decision to you very quickly. And I appreciate everybody, and everybody stay safe.
Thank you.
Wait a minute, let me take us off YouTube.